All rise. The Court of Appeals, Division 1 is now in session.
Thank you all. Please be seated. This is a time set for oral argument in our case, Lamelli versus, hold on.
No, next one.
The wrong one. I apologize, counsel. I apologize. No, that's the Gann versus State of Arizona, our case number CA CV21-0675. And again, apologies for calling the wrong case. Each side is allocated 20 minutes. Appellant, if you wish to reserve a portion of your argument, you're free to do so, but you need to keep track of your own time at the podium clock. Out of respect for counsel, I would ask for all those in attendance to make sure their cell phones are off or in vibrate, and that also will avoid avoidable embarrassment. We have read the briefs. We've conferenced the case. We'd encourage you to keep that in mind as you present oral argument. Our proceedings are being recorded and will be posted on YouTube in due course. So please, as you present your argument, please start with telling us your name and the party that you represent. With that, Mr. Abney, you may proceed.
May it please the court, my name is David Abney. I'm representing the appellant. Thank you for the opportunity to have oral argument. As I was preparing last night and doing other things, I learned two new things about Harry S. Truman, that his middle initial S is just an initial, it's not a name at all, and that he had a handmade, very rustic sign on his desk that said, "The buck stops here." I also learned a third thing this morning. It wasn't on the Resolute desk. He didn't use that desk very often. It was not in the Oval Office. But
sometimes you see the S without a period,
right,
for that very reason.
Yeah. I think Ulysses S. Grant had the same problem. I'm not too sure about it. But I know Harry Truman didn't. He just got tired of filling out forms with, couldn't put anything for the middle initial. The buck stops here with the state as far as pupil transportation is concerned, and it stops here for three reasons. First is the Enabling Act, which is the primary law in Arizona, even above the state constitution, and it provides in Section 26 that the schools, colleges, and universities provided for in this act shall forever remain under the exclusive control of the said state. The constitutional framers watered that down slightly in their Article 11, Section 2, when they talk about the general conduct and supervision of the public school system shall be vested in the State Board of Education, a state superintendent of public instruction, county school superintendents, and such governing boards for the state institutions as may be provided by law. But for pupil transportation, the legislature was very emphatic when it passed ARS Section 15921A, and it says, quote, "The superintendent of public instruction shall supervise the provision of pupil transportation services," end quote. And the shall supervise is mandatory. You must supervise it. Now, we talk about a non-delegable duty, and this is one of those non-delegable duties. It doesn't mean that the state can't allow counties, school districts, community colleges, whoever is running transportation, to run the transportation system for pupils, and that's fine. But non-delegable does mean that you can't delegate away your liability. Ultimate liability for pupil transportation for public students in the state of Arizona is with the state.
Has any case ever extended a non-delegable duty to the state, from a student to the state, under the Enabling Act?
No, not that I'm aware of. There are a number of cases about the Enabling Act and the importance of education to the state, which makes sense given the progressive era. The progressivists, or the liberals, as they would call themselves in their day, believe very firmly that you should have centralized control as far as possible, professional, centralized, technical control over such things as public education. Because public education in the United States, as of 1910, 1912, was a bit of a wreck in most states and the remaining territories, New Mexico and Arizona at that time. The local boards were not doing a very good job, and public education was really suffering as a result. They wanted the state to control it.
Because you mentioned it, has New Mexico ever found such a duty? Because New Mexico used the same Enabling Act.
Not as far as I know. But then again, people tend to ignore their fundamental charters. We're all educated and indoctrinated at law school to look to the federal Constitution as the source of all rights and protections, and it's the state Constitution that really matters most to us, and it should matter most to us. And then, of course, the Enabling Act is almost universally ignored, but as a matter of fundamental Arizona law, it controls. It controls even over the Constitution. So we do have a source here for duty. I mean, I've been up here, I don't know how many times on duty cases, and sometimes I've gotten my head chopped off and sometimes not, but duty has been a central problem in Arizona jurisprudence since the beginning. Of course, since Gibson versus Casey, it's come to the forefront. It is a soup du jour with defense firms everywhere that they talk about duty. But here I've got duty, finally. I've got a very strong statement of duty in the Enabling Act, a good statement in the Constitution, and a very firm, clear statement by statute.
Where's the safety aspect in the Enabling Act?
Pardon me, Your Honor?
What about that would suggest that it was for safety of the students? I mean, normally for this kind of duty, we also see that it's for safety purposes, for a particular person.
I think that's inherent when you talk about you shall supervise the provision of pupil transportation services, not simply to make sure that they have a bus, but also that the bus is safe.
Okay, but you moved off of the Enabling Act with that language, I believe. Did you, which quote did you just use?
ARS Section 15921A.
Right,
It talks
and so
about shall supervise.
we were talking about the Enabling Act, so I wanted to focus on that. Where's the safety aspect in the Enabling Act that we can use that at all?
I believe that the Enabling Act can be a source of duty just by its terms. It specifies that the schools are under the exclusive control of the state. Well, exclusive control means you've got the whole kit and caboodle. It's in your lap. If you want to delegate away things to the counties, to local school districts, that's fine, but you can't get around that you're the one that has the exclusive control ultimately. And with control comes responsibility. There's a duty to make sure not only that there's transportation, but that it's safe. It's inherent. I mean, you don't just give them a bus, you give them a bus that's safe. You don't just give them any driver on earth, you give them a driver who's certified and licensed. You make sure that your duty is fulfilled in a non-negligent way.
Well, then let's unpack that, because the school district under Arizona state law doesn't have to provide any transportation.
Yeah, but if
It's
you do-
discretionary to the school district. So how does that create a non-delegable duty flowing all the way up to the state when it's the school district alone that makes that decision?
Well, it's not. It's the school district that are making these sorts of decisions, but they are underneath the state itself. And the state is the one that has the exclusive control that shall supervise all this. If the state decides it's not going to supervise it, it doesn't want to do that.
So is the state liable for anything that happens to a student for which the school could be held liable? And that's what you seem to be arguing, which is a very expansive duty created on behalf of the state.
There's a possibility that someone could try to do that in the future, and I don't know about that future case.
Well, how
But
would we
here-
limit it?
But, pardon me?
How would we limit it?
I don't know. I don't know what would happen in a future case. I haven't thought about it or briefed it, but I know in this particular case, where the legislature specifically says you shall supervise the provision of pupil transportation services in this particular aspect of the educational format, educational system, the state is the one that shall supervise the provision of those services.
And
if the
now,
state-
I want to be clear, you're going first to the 15921, I believe it is?
Right.
And isn't that, that falls within the budgeting and financial assistance section of statute. Everything about that statute relates to financing and budgeting, which would make sense within the context of saying saying supervisory. It's a budgeting, it's a factor of budgeting for the state, not a factor of providing actual services.
Well, that's what the government argues, but the government's argument ignores the plain language of that clause. It's very clear. Doesn't say anything about budgeting. Shall supervise the budgeting of public transportation services. Nope, it doesn't say that. The plain words say shall supervise the provision of pupil transportation services. It doesn't say anything about budgeting or anything like that.
Go ahead. No, go ahead.
No.
To follow up on Judge Goss's question, the first time in this kind of hierarchy that you've described, Enabling Act, Arizona Constitution, education statutes, and I understand there are other provisions we may want to talk about too, but the first time we get to anything specifying transportation is Title 15, right? 15.921. So nothing in there in the Enabling Act and nothing on transportation in the Arizona Constitution.
Nothing
right?
specific, no.
And so, just to kind of follow up with Judge Goss's question, if your argument is the Enabling Act and the Arizona Constitution create the state to have a duty for all local education services of any kind, how would that not create sort of automatic liability for the state anytime a student, a visitor, a teacher, anyone involved, an opposing football player, anyone involved in education services in primary and secondary schools for Arizona public schools to be liable? How would that work?
Well, it might. It might create that kind of broad liability. I did not focus on that because it wasn't before the court, but to be an honest answer for me has to be it might create that kind of liability. But maybe that's really what Congress intended back in 1910, and to some extent what the framers of our Constitution intended when they put the Constitution together in 1910, also in 1910. But the thing about the statute we're dealing with right now is it's very specific. It's very clear, no qualifiers, nothing about finances in it at all. It simply says you shall supervise the provision of pupil transportation services. And if the legislature had wanted to limit that in some way to only financial matters, they could have easily put in an adjective or two, and they didn't.
Well, we could read it in context, that it did put it in the budgeting section of the education provisions. It didn't put it, and let's talk about where it did put a duty, and that's in ARS 515, I think it's 342. Let me double check myself here. 12. Because that's where the state talked about the actual duty, and it said, in that case, that the school board has the discretion to provide transportation or site transportation, loading and unloading for any child, if it's deemed in the best interest of the district. And so when it wanted to impose a duty, it did so, and it made a discretionary call on it for the school districts. That in that context, it's clearly the school boards, and it's done within the statutes where it establishes the obligations, and in fact, the obligations established under 251 for the superintendent and 252 don't identify transportation.
The state can delegate. That's the point. The state can delegate the performance of its duty, but it cannot delegate away its liability. No matter what, under the Enabling Act, the state simply can't do it. The state has exclusive control.
Well, are you basically arguing then, and you mentioned vicarious liability, that the state is the respondeat superior in all of the school district matters, that they're vicariously liable somehow?
Yes, but it's not a common law vicarious liability or respondeat superior liability. There's nothing about the common law here. This is Enabling Act. This is a congressional directive. You state, you have the exclusive control over the schools.
Okay.
Nobody
So you're conceding, at least at this point, that there's no vicarious liability issue before us?
No.
Okay.
What I'm saying is there is Enabling Act vicarious liability. There is constitutional vicarious liability. There is statutory vicarious liability. Common law has nothing to do with this particular situation.
And because on page 28 you do say for vicarious liability to exist under a non-delegable duty. So I just wanted to make that clear.
Yeah, no, the state is liable, whether you call it vicarious liability, constitutional, Enabling Act, statutory, whatever you might look at it. You are liable, even if you don't do anything. Of course, the state in this particular case didn't do anything.
So is your argument, as I understand it, plainly and simply, the state had a duty to ban 15 passenger vans, and that is the breach?
The state had a duty to ensure safe transportation for this particular student and all other students. If it breached that duty involves a standard of care. That's a fact question. The only thing we're dealing with right now is the duty. Is there a duty? And yes, there is a duty. Enabling Act, Constitution, statutory. The duty exists. How you fulfill that duty is standard of care.
Okay.
I think I briefed the other stuff moderately well for me. May I save my remaining time?
You may.
All right, thank you.
Thank you. Ms. Garner.
Good morning. May it please the court, my name is Deborah Garner and I represent the state of Arizona in this matter. I'm going to address two main issues today. The one that we've discussed quite a bit is the duty issue, as well as that the state is entitled to absolute immunity for its discretionary administrative decision regarding what specific rules to adopt in this particular case, whether or not to ban 15-passenger vans. Now, Gann wants this court to find that a duty existed based upon the Enabling Act. And as you indicated in your questioning, there just is nothing within that Enabling Act that provides any sort of duty. When we are looking at how to determine what statutes create a duty, we have to look at whether it was created in order to protect a particular individual or particular group of people, and if that harm was the type the statute sought to protect. There is nothing within the Enabling Act or in the Constitution, and quite honestly in Arizona Section 15921A that creates those sorts of that has those sorts of requirements. So what we have to do is we have to look at what the statute, what the legislature intended behind those things. And I'm going to focus specifically on 15921A.
Counsel, before you get there, on the Enabling Act, what if language was added such that the Enabling Act said the states, colleges, and universities provided for in this act shall forever remain under the exclusive control of the state, which shall ensure safe and effective education?
Well, I think that if they intended to do that, they would have added those.
And I understand that, but and I'm asking a hypothetical, if that language existed, would your argument be the same?
Well, I think then we look at to what the delegation of duties to the school districts. The school districts have that exclusive control over the transportation. They have that exclusive control over the students, and the duty would fall to the school districts. They're non-jural entities. They have the power to sue and be sued, and they have that ability to make those decisions regarding the safety of transportation and the students.
And what, if that language existed, wouldn't that alter the thrust of Article 11, Section 2 of the Constitution, which talks about various and sundry entities, including the state, that are responsible?
Well, I think that's possible, but then we have to look at what that would create. That would create a duty of the state to everyone, everywhere, and that is just not what the case law provides for, that the state doesn't have a duty to everyone, everywhere.
Well, and you've heard appellant's counsel in the court's question that if the appellant is right on the Enabling Act, would that create a duty to everyone, everywhere for the state, or at least, perhaps not a duty, but at least responsibility for injuries involving schools?
I think that it would, and it would certainly create a lot of difficulties for the state when they are delegating their duties to other individual entities. The state just can't be responsible for everyone all of the time. That is clear in the case law, and if we are going to create such a duty, that would go beyond case law, that would go beyond what is required of the Constitution in the state.
And the Article 11, Section 2 also contains a provision as provided by law. And so it seems to me that section does carry you down a little further, but you then need to move beyond that to a statute to get any authority.
Correct. And then if you go into the statute that he relies on, that 15921, we look at the statute as a whole and in context, which you've already discussed, and it specifically states it is within the budgeting statute. And if the state or the legislature intended for that statute to create a duty, or a safety duty, they would have added that language. In fact, there is language further up in Title 15 that does require safety provisions by the state, and it doesn't indicate it there either. But if the state had intended, or the legislature had intended for the state of Arizona to provide a tort duty for pupil transportation, it's likely they would put it in the safety provision rather in a budgetary provision.
So let me follow up on that point. I want to move off of the education statutes into the transportation statutes, because there, 28900A does say that DPS shall adopt rules as necessary to improve the safety and welfare of school bus passengers by minimizing the probability of accidents. And it goes on that the minimum needs to meet the federal standards. How does that not create a duty?
So I think that the duty is, again, that DPS is to create these specific regulations to provide for that safety. And DPS did do that. They created multiple regulations that we referred to in our briefing to provide for safe transportation for students. And what plaintiff, or Gann, wants this court to do in this case is to add to that and add an additional requirement to ban 15 passenger buses. But the state has absolute immunity for those particular, for creating policy decisions, and that is clearly a policy decision, adding to the rules and regulations. The state has discretion in determining what rules and regulations to enact. They added those, they included those in their statute, and second guessing what the state has done and provided for is really not the role of the judicial.
Are you acknowledging the duty was created and it's immunity that protects the state, or are you arguing that it doesn't create a duty in the first instance?
I think that the duty is created to DPS in order to enact those statutes, and they did those things. They met that duty when they provided for those statutes. And then the duty then falls upon the school districts who have that special relationship with the students to ensure that that safety is provided for those students.
Counsel, do I hear your argument on that point with immunity being that if DPS, let me ask you a hypothetical, enacts rules that are just demonstrably wrong and bad, that's untouchable, could never be challenged in court unless there was a procedural problem?
I think that that's true. The implementation of those rules and regulations is where the court system and the judicial system could challenge whether or not the state or the school district breached those duties. But creating those policies and decisions is something that the state is entitled to absolute immunity for.
But does it create a duty to the students? That's what I'm trying to unpack. Are you saying that in establishing those parameters, that actually creates a duty to the students, or are you recognizing there's a break?
I think it creates the duty to DPS, and then it is the school district that has the duty to provide, to implement those provisions and provide those, to ensure that those safety provisions are followed.
Okay.
Your Honors, I wanted to just point out specifically the Evanstead case, which refers to and talks about the absolute immunity argument. And this is a case that is right on point with the facts of this case, and it's a case that was not addressed by plaintiff, or Gann, in any of his briefing. And in that particular case, I think it establishes the argument that I'm making regarding that the state is absolutely immune from creating and developing those policy decisions. And in the Evanstead case, again, which is right on point, it involved a family who sued the Department of Motor Vehicles, the Motor Vehicle Department, stating that they did not create sufficient laws, sufficient rules and regulations regarding licensing, particularly licensing of an individual who had habitual drunk driving charges. And the court found in that case that, that the director of MVD had adopted sufficient rules and regulations, and that the state was specifically immune for the discretionary administrative decisions. And I think that that falls the same here. We have a state who has the section 28900 that we've discussed, and DPS complied with that and established the rules and regulations. Now, DPS could have adopted different rules and regulations, but it is discretionary, and it was based on their clear discretion in determining which rules to promulgate.
In that regard, there is no legal issue or factual issue whether or not the federal law requires the banning of these 15 passenger vans, is there?
I don't know that the federal law does require banning of those. I think that, what plaintiff has indicated, and we haven't, really developed the facts of this case since it was a motion to dismiss. But their argument is that there were multiple states that have chosen to ban these 15 passenger vans, and that the state of Arizona did not do that. And the argument we're making is that, it is the state's discretion in determining whether or not to ban those those bans.
And I guess what I'm trying to get at is, if the federal government required it, then the state would have violated the statute if it did not ban the vans consistent with federal law, because we have to meet at least the federal standard.
I would concede at that point, but at this point, we haven't reached that.
Okay.
We're here specifically for duty, or the absolute immunity. I think that I've made all the points that I wanted to make. If there are any additional questions, I'm happy to answer them for you. Thank you.
Mr. Abney, rebuttal.
As far as the location of ARS Section 15921A within the particular area of the revised statutes, I don't think that's important. What matters is the plain language of the statute. When we have a whole toolbox of things we use for statutory construction, so many canons, you lose track of them. But one of the most basic ones is you go with the plain language is, if it's unambiguous, you apply that. You don't use any other tool of statutory construction. You look at the plain language and then you apply that, and that's what I suggest the court should be doing in this particular case.
But isn't part of that also, we look at the plain language in context? I believe the cases always say this plain language within the context.
Well, context here is the Article 15 deals with education. That seems like a pretty good context to me for the statute. We talk about, my colleague raised the immunity statute, and the difficulty with trying to apply that here is that it deals with discretionary decisions and whatnot, choices. There's no evidence at all, definitely nothing in the complaint that says the state exercised any discretion whatsoever, never considered whether these 15 passenger vans should be banned or not. If there is a non-decision, if there's no exercise of discretion, then the absolute immunity statute simply does not apply.
Help me better understand that. What if, and I get that this is not the record, which is a 12B sort of record, but what if the record was, hey, the agency looked at this but just decided not to do it? Wouldn't that qualify for absolute immunity under the statute?
It might, yes, sure.
But
unfortunately, that didn't happen.
Well, no, I was going to say, but the argument that you're making is if the agency just didn't think about it, then absolute immunity wouldn't apply ever.
It doesn't apply. It doesn't apply to a non-decision. You actually have to do some sort of decision-making process. And I don't think they could do it ex post facto. If we succeed here, we get the case back on track. I don't think they could come out next month and say, oh, now we've made our decision and it's banned. I don't think you can do that. It's at the time of the event that occurs, logically, would be where you look at absolute immunity.
How far does that go? And and I hate to use names, but, if they said, okay, we don't want the Ford van, and they don't talk about the Chevrolet and the Chrysler and all the other names out there. Does that mean they haven't considered the Chrysler and the others, so they've got absolute immunity for Ford, but hey, they were in a Chevrolet?
That might be the case. It really depends on how specific they were. I can't imagine that a government body would be that specific and nitpicky.
But that's my point, is the specificity. If they looked at vans and they decided what they were going to allow and not allow, they looked at buses and decided, these are the ones we're not going to allow, isn't that specific enough to say they exercise discretion? Because that's my point, is how specific do they need to be to invoke it and avoid liability through absolute immunity?
Pretty specific. This was a very known particular problem across the nation, state after state, and in the federal government. The federal government didn't get around, as far as I know, to banning these things. They should have. But some states have certainly done that. But the federal government certainly disapproved of them, and warning after warning, don't use these things. And we have nothing to show us that the state of Arizona ever considered that one way or the other in doing any sort of regulation or decision-making in this case. And therefore, it doesn't get the benefit of the absolute immunity statute. I mean, we are, after all, supposed to construe these immunity statutes very narrowly, because the rule in Arizona after Stone versus Arizona Highway Commission is that liability is the rule and immunity is to be the exception. And that pulls me back to something, when my colleague was talking, I was scribbling Stone versus Arizona Highway Commission, 1963, and Ryan, which came a few years later. And Ryan said something in it, everybody predicted doom and gloom and destruction of the tort system when the Stone case was decided, and look, we're still here. There's not going to be doom and gloom in this particular case if this court decides to follow the plain language of the statute, to follow the Enabling Act and the Constitution to say, look, there is a duty here. What you have to do to fulfill the duty is standard of care, and you can deal with that at the trial court, and we'll see you in a couple of years if you can't iron that out properly. But what we've got here is duty coming from the top right on down, and when the rubber hits the road and when you get to the statute, it's very clear, very specific language that the superintendent of public instruction shall supervise the provision of pupil transportation services. You can't get much more specific than that. If I may rest on my briefs, and I'll rest my brief on my chair. Thank you very much.
You may. Counsel, thank you. We very much appreciate your briefing and your oral presentation today. We will take the matter under advisement. We'll issue a ruling in writing in due course. Court stands in recess while we set up for next oral.
Thank you.